Welcome back to the Winning Brief Soundbites. I'm Mabel. In episode 4, we looked at ecocide, Belgium's landmark new environmental crime. Today, we stay with the new offenses and turn to white-collar crime. By the end of this episode, you'll understand how the new criminal code reshapes fraud and money laundering, why criminal attempts are now treated differently, and you'll practice phrases you can use when advising clients on financial crime exposure. The new Belgian criminal code makes significant changes to some of the most commonly prosecuted white-collar offenses. Let's start with fraud. Under the old code, fraud required the actual transfer or delivery of money or goods. In other words, if someone used fraudulent means to trick a victim, but the victim had not yet handed anything over, technically, the fraud was not complete. You could say the old code rewarded con artists for bad timing. The new code closes that gap. It is now sufficient that the perpetrator sought an unlawful economic advantage using fraudulent means and with fraudulent intent. The money does not need to change hands. That is a major expansion of the offense. Money laundering has also been overhauled. Belgium punishes money laundering through 3 separate offenses, and all 3 have been tightened. The most notable change, the person who committed the original crime, the predicate offense, can now also be prosecuted for possessing or handling the proceeds. And the new code adds mandatory aggravating circumstances if the offender is a regulated entity. A bank, for example, the court must take that into account when setting the penalty. And here is a change that cuts across all offenses: criminal attempts. Under the old code, attempting to commit a misdemeanor was generally not punishable unless a specific law said otherwise. That distinction is gone. Under the new code, attempting any intentional offense is now punishable at the immediately lower sentencing level. So, if the completed offense sits at level 4, the attempt is punished at level 3. For prosecutors, this is a significant new tool. For defense lawyers, it is a significant new risk to manage. So why does this matter for your practice? First, the fraud reform removes what was essentially a technicality that benefited bad actors. Clients in financial services, procurement, and commercial contracting should understand that the threshold for criminal fraud in Belgium is now lower. You no longer need to show that the scheme succeeded, only that it was set in motion with intent. Second, the money laundering changes create real exposure for regulated entities. If your client is a bank or financial institution, the mandatory aggravating circumstance means the institution's status itself becomes a factor in sentencing. That is not something you can argue away. It is built into the structure of the offense. And third, the expansion of punishable attempts changes how you assess risk for clients. An act that previously fell short of a completed offense and therefore carried no criminal liability may now be prosecuted as an attempt. That shifts the line between legal and criminal conduct, and your clients need to know where that line has moved. Now, let's practice some of the phrases from today's episode. 1. The new code closes that gap. Closes that gap means the law now covers something that was previously unregulated or unenforceable. It is concise and works well when explaining legislative reform. 2. The money does not need to change hands. Plain, direct, and immediately understood. This is the kind of sentence that makes a complex legal change concrete for a non-specialist audience. 3. The person who committed the predicate offense can now also be prosecuted. Predicate offense is the underlying crime that generates the proceeds, which are then laundered. It is essential vocabulary in any money laundering discussion. The institution's status itself becomes a factor in sentencing. Becomes a factor in tells your audience that something now carries legal weight in the court's decision. It is precise without being technical. 5. That shifts the line between legal and criminal conduct. Shifts the line is a powerful image. It tells your audience that what was previously safe may no longer be. Use it when the law redraws boundaries. Time to practice. Repeat after me. The new code closes that gap. The money does not need to change hands. The person who committed the predicate offense can now also be prosecuted. The institution's status itself becomes a factor in sentencing. That shifts the line between legal and criminal conduct. Well done! In our final episode, episode 6, we bring it all together. What the new criminal code means in practice for lawyers advising clients in Belgium and what to prepare for next. Until next time, keep practicing. Fraud, money laundering, criminal attempts. The terminology is changing and the stakes are higher. If your team needs to discuss financial crime clearly and precisely in English, I can help. You can find my work and book a conversation at thewinningbrief.eu.